Right, this is Laws 12066 Land Law, and this is topic 2 on our first instalment of 3 topics over 3 weeks on the Torrens system of land registration. And our focus in this first lecture is in relation to explaining the nature of the Torrens system, to introduce you to some of the primary materials that you'll need to consult in regard to the Torrens system of title registration, and to explain some of the foundation concepts or ideas. So we'll just start by sharing the slides, and there we are. This is our first instalment on this critically important area of land law, and that is the system of land registration, which now traverses all the states and territories of Australia. It started in South Australia in the 1850s, introduced by Robert Torrens, after which the framework takes its name, but it doesn't have that name in the legislation in the different jurisdictions. And it's actually different. I mean, in Queensland, we refer to the Land Title Act. New South Wales is the Real Property Act. South Australia is the Real Property Act. Victoria is Transfer of Land Act, similarly in Western Australia, and so on. Different titles to the legislation, but and importantly, as I've already emphasised in the first class or first lecture, that the legislation is state-based, and it is not an exact mirror version of the provisions in one act into another act, but the structure and the essential concepts and what it seeks to achieve is largely the same, of course. So what we want to achieve in this lecture is, or in this presentation is, as I indicated, we'll start just by a very brief touching on the deeds registration system, which preceded the enactment of the land title of the Torrens legislation, the Torrens framework, as a way of trying to provide more security around interests in land through a system of registering the title that it was acquired through an old system conveyance, which required the proof of good root of title. That's no longer relevant in Queensland, because under the Land Title Act, all of those old system titles have been rolled over into the Torrens system. So as I mentioned in the first lecture, all private freehold in Queensland is Torrens title under the provisions of the Land Title Act 1994, Queensland. So I'll just make a brief mention of that. We want to then move on to the fundamental idea that that really centrally underpins the Torrens system, and that is this concept of indefeasibility. And that's referred to actually in the Queensland Land Title Act. It isn't referred to in all of the Torrens Acts across the Australian landscape. For example, New South Wales does not refer to the concept of indefeasibility, but rather through the equivalent provisions that deal with this idea, it talks about paramountcy of title of the registered proprietor. So that's a slightly different way. And some jurisdictions identify the concept by name of indefeasibility and try to document it to some degree, but it's not an entire documentation in the Act itself. Case law is still critical in terms of helping us to understand the nature of the key concept. But in some jurisdictions it's not referred to, but then the case law documents this notion of indefeasibility in relation to this cognate idea of paramountcy of title. We want to just have a look at some of the development that stands behind the system that we have today, and in particular some of the key ideas, the key provisions within the Land Title Act Queensland. Importantly, we need to then touch upon the theories that were in the early development of Torrens title. There was two major theories that were vying for attention, if you like. Immediate and deferred indefeasibility. Now, deferred indefeasibility came first, but it's important for you to understand today that the accepted theory is immediate indefeasibility. So immediate indefeasibility of title. But we need to see, well, how did this other idea of deferred indefeasibility arise? We need to look at and appreciate and evaluate how the concept of indefeasibility not only applies to ownership itself, or using the terminology or the nomenclature of the legislation, to registered proprietorship under the Act, but can it extend to include other individual terms or provisions that might be in documents that aren't necessarily there on the title itself? Because we'll have a little look at an example of a certificate of title, even though in Queensland today certificates of title, or indefeasible titles as they're referred to under the Act, that's the Land Title Act, the LTA as I'll refer to it by way of abbreviation, do not issue as a matter of course, and other jurisdictions are following in that line, particularly in light of electronic conveyancing. No need for the issue of documents. They're stored electronically, and you can do a search and get the details as you need them. Any stakeholder that's involved in a particular lot or parcel of land. But this idea of what does indefeasibility extend to apply to? That's the key idea that we're trying to grasp there. How far does it go? And then to appreciate and evaluate the impact of being a volunteer as an exception to indefeasibility under the Land Title Act. So it's a bit, sometimes knowing where to put the idea of volunteers is interesting, and we'll just touch upon that, and I'll refer you to the relevant section in Queensland, which this is covered under the Land Title Act. You can see there at the bottom of the slide the reference to the prescribed reading for this topic, and of course the casebook is the primary reading, and we're into chapter 5, page 411, folks. Page 411, but of course we've done all the other stuff, all the other earlier pages up to this point in the Term 1 course. Now, in this topic, or this class or lecture, we're dealing with that part of chapter 5, as you can see there from paragraph 5.1 over to 5.74 inclusive, and that's pages 411 to page 470. About 60 pages of Sackville and Neve. Light reading, bedtime reading. Don't underestimate the challenges that lie ahead in the material in land law, but I'm trying to give you manageable chunks to work with on a topic by topic or week by week basis, and not try and overwhelm you, but there's a fair bit of material even within those 60 pages, provisions of legislation, case law, and commentary by the casebook writers. Just again, of course, understand that's a book that's written for all jurisdictions, so it refers to provisions from other jurisdictions and so forth. You just need to focus on the Queensland position, but that means focusing on the Queensland legislation and then the case law as it is relevant to help us understand what the Queensland provisions are saying in relation to under the Land Title Act, Property Law Act, and so on. The cases are not always discussing those legislative provisions. And so we need to see to what extent it's applicable. But in terms of the case law discussing the ideas and the concepts and exploring those and helping to enlarge our grasp of that, that's how the case law is of critical importance. And of course, it is highly relevant. So I'm just going to stop screen sharing. Before I do that, just those, again, key terms, indefeasibility, the Torrens system, and deeds registration as key terms in this particular topic. So the deeds registration system, as I mentioned before, again, this is just really, in Queensland, it's a little bit more relevant in other jurisdictions because there is a very tiny percentage, for example, in New South Wales, less than 1% is old system title, which is the form of title that was acquired by proving a good root of title over a period of time, originally about 30 years. But you had to go back and trace all the documents that gave the links in the title, and if there was any problem in any of those, that would cause a problem for the current purchaser. So that's no longer necessary. That was the common law system of establishing title that's derived from English conveyancing practice. That's no longer relevant in Queensland. It is relevant in very, very limited circumstances in other jurisdictions. And actually today it's become quite specialised. And I don't want to spend too much time on that, but provisions in relation to that are still preserved within the Property Law Act. So you can have a look at those provisions, sections 241 to 249. But as I indicated, this is largely something that's of historical relevance. So when we come across to think about the Torrens system in terms of where do we go to find the resources that we need, apart from, in due course we'll come to the case law. But so we go to Queensland Department of Natural Resources mines, and we're looking there in terms of the proper land registry access point. So I'll just stop screen sharing that for a moment, and I'm going to right. So we can see here that in terms of the Queensland Government portal, you can follow the links, if you like, and you can see the website there up in the web bar. If we call it the web bar, I think it's called web bar. That you can get information. This is not the land title site, but it is information about freehold land administration as part of some general discussion. And I just thought I'd show you this because it gives you a bit of an historical perspective, and you can have a look at the go onto that site yourself about Torrens title in Queensland, and where it started with the Real Property Act of 1861, for example, which wasn't long after the enactment of the Real Property Act in South Australia by Robert Torrens himself. But today, as indicated there, a bit further down, the modern Act, and it's quite modern, a modern piece of legislation in Queensland, the Land Title Act 1994. But what's interesting, I think, in this particular web page is we have a sample there of the first certificate of title under the then Real Property Act of 1861, and it's an interesting historical artefact. In fact, several years ago when I was in Brisbane, I went and visited the land titles registry, and they've got the actual original certificate framed and in glass and preserved, and mounted on the wall. It's actually quite impressive to just go up and examine it, and you can see, as the the old-fashioned writing and the signatures and the seals, and this is really what, you know, sort of brings this to life in a sense from an historical point of view. Of course, today with most things being electronic, all these bits and pieces and so forth have faded into the historical ether, if you like. But it's still interesting, I think, to go and have a look at that. And if you're in Brisbane and if you happen to be near the land registry, you can go in there and you can actually have a look at some of these historical documents. I'll just stop screen sharing that for a moment. Just come back to the slides. So we then also, I'll come back to Queensland Globe in a moment. So right, the key legislation with regard to Torrens title is the Land Title Act, but we also have another document which is actually recognised in the Land Title Act itself, and that is what's referred to as the Land Title Practice Manual. So I just want to show you that. I'm just going to screen share that. So what we find here is, and again, I encourage you always, with regard to legislation, to access the official legislation site. In Queensland, that's Queensland legislation. And also, if you're looking at legislation in other jurisdictions, federal or Commonwealth legislation, always go to the official site, not necessarily AUSTLE. AUSTLE is not the official site. It's useful, absolutely it's useful, but it's not the official site. So if you're wanting to make sure that you've got the official version, and as an online version, save these as hyperlinks throughout the course, this is the place to go. So we find in the Land Title Act, you can see it's covering a whole range of matters. There's been amendments to incorporate electronic conveyancing, as you can see there, Division 2A. The Freehold Land Register set up under Part 3. And there you can see under Division 2 of Part 3 is the reference to indefeasible title. And that's not, as I mentioned to you initially, that's not in every jurisdiction where it's actually identified as indefeasible title and set up quite in that way. And so you can have a look through the various parts of that. We'll be referring to different sections within the LTA throughout the course. I'll even be referring to some sections today in this lecture. So that's the Land Title Act. The other, stop screen sharing that for a moment. Then I just want to show you something else. And so this is the Land Title Practice Manual, which you can download from the Department of Natural Resources and Mines website. And you can either have it accessible in an electronic form, you can download a PDF version. I certainly encourage you strongly to have access to the LTPM throughout the course. You'll also find it useful, I think, in relation to assessments. And it's a critical document along with the legislation itself. And you can see that it's got a number of parts to it. It's quite an extensive document. And you scan through that, you'll see that not all of that, of course, but several of those areas we will be specifically dealing with in this course. So you can see references there to mortgages. You'll be able to see leases, Part 7, easements, something about Part 11, caveats. We'll talk about that when we look at topic 4 on unregistered interests, part 1 with regard to transfers, and the first, I'd encourage you just to have a look at the introduction to the registry. The titles registry, I've given you, I think, that part of the LTM, Land Title Practice Manual, on the Moodle site for this topic. Just get a general acquaintance with the manual and know that you can go there. It gives you clarification. It shows you things about the various aspects of the Land Title Act. Importantly, it also provides information about forms and about procedures in relation to the processes around Torrens title. So that's an important document to be aware of. Right, so we're just going to go back to slides. Now, I just want to go back to Queensland Globe, and Queensland Globe is something also that you need to acquaint yourself with. I'll just stop screen sharing that and share with you the site for Queensland Globe. Again, the Queensland Government portal for Business Queensland. Queensland Globe is really interesting, and it's a spatial cadastral mapping of the whole of Queensland, and other registries have developed similar cadastral mapping and geospatial technology. And this has a lot of information that's beyond what we do in this course or in this unit. But there is also property law information there, and we'll talk more about that, and I might, in a separate presentation, just show you a bit more about Queensland Globe and how it works and how you can find the relevant information. But I encourage you to go onto the Queensland Globe site to activate it for you on your browser. You can even download it on your mobile phone or your device and play with it whenever you want, on the train, on the bus. You've got a spare moment, you can play on Queensland Globe. Why wouldn't you, right? So it gives you fantastic information from a spatial perspective around all of the various aspects and features that affect a lot of land or a parcel of land. You can even go in there and you can have a three-dimensional image of that, and there are videos that you can look at that help to explain Queensland Globe and how it works and operates. So really suggest and want you to familiarise yourself with the operation of that. Insofar as it's relevant for what we're doing in the course, it has a wider reach than what we're covering, but relevant for us as well. I'll just come back to the slides. So that's Queensland Globe. Just coming back to Land Title Act, Section 184 is a relevant section for us in terms of thinking about indefeasibility, and you need to have a look at that section in relation to the idea of indefeasibility. So these competing theories of immediate and deferred indefeasibility, how did they arise? They arose because originally the courts were not sure about what registering your interest under the Torrens system actually meant. And it was difficult for the courts initially, in the law, the courts, really, the judges, to fully acknowledge at least one train of thinking, put it like that, that interests which were off register couldn't somehow affect the interest that was being registered and what was in the quality of title that was being acquired by registration. Couldn't quite accept that, and it's actually part of the ongoing struggle between this system of registered title on the one hand, or title by registration, that's how it's referred to since the famous Australian High Court decision of Breskvar and Wall, Fraser and Walker, which we'll just touch on in a moment. Fraser and Walker is the Privy Council decision, Breskvar and Wall is the High Court decision, where that established, particularly Chief Justice Barwick's statement in Breskvar and Wall, that it is a system of title by registration. That is, it's the act of registering which creates the title. You're not registering something that you already have. No. And this is what was a bit unclear for some judges earlier on, insofar as they couldn't believe that the system would have the effect of squashing or refusing to acknowledge other potential interests that should be otherwise recognised. So you can have a look at these diagrams that I've created in relation to both immediate indefeasibility and deferred indefeasibility. And as I said, immediate indefeasibility is the theory of indefeasibility which we need to focus on today. That is the doctrine that supports our current understanding and awareness of how the Torrens framework works, so that, you know, the idea of immediate indefeasibility is that that is acquired by the act of registration. It's immediate. There's no deferral. Whereas in the idea of deferred indefeasibility, you can see there that if there's an issue affecting the registering party, the purchaser, transferee, for example, in a sale transaction, and the instrument that's being used for the creation of the interest, the transfer, for example, is void, some problem with it, some legal issue with it, and they haven't acquired, if the purchaser, how the purchaser has acquired their interest is the issues there, then this deferred indefeasibility suggests that they don't really get that indefeasibility immediately. It's deferred until a later point, and so you can have a look at that. We'll talk more about that in the tutorial, and I'll get your thoughts and reactions to that. And you just got to, you've got to get your head around it a bit, and you can see, for example, in the case book, you will find these theories discussed. So the principle of indefeasibility starts on page 420, paragraph 5.25, and then this discussion around these competing theories starts at paragraph 5.34 on page 424 of the current edition of the book. And the truth here is that the deferred theory really harks back to a judgment by Dixon in Clements and Ellis back in 1934. And then we had these other decisions, Fraser and Walker and Breskvar and Wall in particular, coming along much later and establishing, no, this is a system of title by registration. Indefeasibility is acquired at the time of registration of the interest, and issues around void transfer and so forth, that doesn't affect that. That was the whole issue. Surely if there's a problem with the instrument, then that's going to have a flow-on effect with regard to the quality of title that the registering party has. Well, immediate indefeasibility says no, that's not the case. Gibbs and Messer is a bit of an exception to that, because what we had there was we had a fabricated entity, or in the situation, and that created a special case which has been a bit quarantined over time. The interesting thing is that Chief Justice Barwick was actually sat on both the Fraser and Walker Privy Council decision, and also was the Chief Justice in Bresvar and Wall. You might say, well, how on earth is that if he's the Australian Chief Justice? Well, in those days, the Privy Council, which sat and I think still sits at number 11 Downing Street, it could also call upon senior colonial, in quotes, colonial court judges, not that Australia was really a colony in 1967, but senior judges from former colonial jurisdictions where appeals still lay to the Privy Council, or where they had, and they could sit as part of the Privy Council, and that's exactly what Chief Justice Barwick did. He sat on the Judicial Committee of the Privy Council in the decision in Fraser and Walker. It's sometimes an historical footnote which is not always fully acknowledged. And he wrote the lead judgment in Bresvar and Wall, and essentially there's a confirmation of the thinking from Fraser and Walker into the situation in Bresvar and Wall. I'm just going to stop screen sharing that just for a minute and just had to show you something. So I've just put this on the website for you as well. So there we are, Judicial Committee of the Privy Council. And you might think this is a bit of a historical artefact in terms of Australian jurisprudence, but the truth is that Privy Council decisions early in our history were quite important, and we still read Privy Council decisions, and Gibbs and Messer is an example of that, and there are others as we travel through this unit, and I'm sure in your other units. But it's just interesting that the composition, the permanent composition of the Judicial Committee of the Privy Council is made up of the Law Lords, and they now sit as justices of the United Kingdom Supreme Court since 2009, but they still hold the title of Law Lord, apart from the President, Lady Hale, who is the President of the Court of the Supreme Court. So that's the Judicial Committee of the Privy Council. Just come back to slides. So we find that the early decision of Gibbs and Messer is really looking at this situation where we've got a forger who has he basically has fabricated his situation, and the point that the Privy Council makes and Lord Watson makes in Gibbs and Messer is that we were looking at a first transferee, right, person that has first acquired the property by way of transfer. The Privy Council said that cannot by registration of a forged deed acquire a valid title in their own person, although the fact of their being registered will enable them to pass a valid right to third parties who purchase from them in good faith and for onerous consideration. So again, this was decided back in the 19th century, 1891, and it's never been overturned. Gibbs and Messer has never been overturned. Quarantined, but never been overturned. You can see still focusing on the nature of the document, the deed, the validity of the title. But yes, we understand registration is where it takes place. This is the effect that it has. But looking at also the effect of good faith and purchasing for value. So these ideas that were relevant under the existing general law, English general law of conveyancing in terms of how a title was acquired, was still there and having an effect in terms of the thinking about this system. When we move to Fraser and Walker, and I don't want to go through all of the facts in Fraser and Walker. You can see I've given you a diagram. I've also given you a discussion of Fraser and Walker, a little bit involved in terms of how the the facts arise, and you just got to get your head around that. That what we had was, and again, as I said, Privy Council decision in 1967, that this involved a mortgage situation, and we had the court looking at, well, what is the effect of this system, essentially, this Torrens system? And the reality was that the court came to the view that this was a system of title, effectively title by registration. When we move to the decision of Bresvar and Wall, very significant High Court decision, which, again involved situation of fraud some fraud happening, and inserting of names onto documents, property law instruments that were not appropriate because there was fraud at play in the process. And there was issues in this particular case, and interestingly enough, this case started in Queensland. Okay, you can see their reference to the Queensland Stamp Act. In terms of non-compliance leading to the actual transfer itself being void, therefore couldn't be enforced because it wasn't statutorily compliant with the Stamp Act, for example. Well, what effect did this have in the instance where there was issues at play affecting, potentially affecting the parties and the interests that they had? Barwick, in a seminal statement, which is oft repeated in subsequent decisions, and we'll see even most recently in another later topic, later lecture on this, on the Torrens system, in 2015, probably the most recent High Court decision, and the significant decision of Cassegrain and Gerard Cassegrain, which we'll refer to, as I say, a bit later in our discussions on the Torrens framework, reiterate this point taken from Bresvar, but in the judgment of Barwick. And it's been, as I said, oft repeated by a range of courts and judges since it was stated. So Barwick basically said the Torrens system of registered title, of which this Act is a form, as you're looking at this particular Act in Queensland, it's not a system of registration of title, but is a system of title by registration. That is, you acquire your title by the act of registering. You do not register an already existing title. That which the CT describes is not the title which the registered proprietor formerly had, or which, but for registration, would have had. The title it certifies is not historical or derivative. It is the title which registration itself has vested in the proprietor. Consequently, a registration which results from a void instrument is effective according to the terms of registration. That's pretty significant. Basically, Barwick is saying, I've got a faulty, dodgy document, transfer, lodged for registration, void under general law for whatever reason. Once registered, the transferee acquires indefeasibility of title. We will subsequently see that there are exceptions to this indefeasibility principle, and important ones, including fraud, which is a big one. But that's for another lecture, and it's also challenging in its own right. It matters not what the cause or reason for which the instrument is void. The affirmation by the Privy Council in Fraser of the decision of the Supreme Court in Boyd now places that conclusion beyond question. Well, it's interesting, of course, that Barwick was also a member of the Judicial Committee of the Privy Council in the decision in Fraser, as I mentioned to you before. But be that as it may, That's the significant conclusion that comes out of the seminal authority of Bresvar and Wall, decided by the High Court in 1971, which gives force to the theory of immediate indefeasibility. But then we have to ask the question, how far does indefeasibility go? Indefeasibility for what? What does it extend to include, for example? And this takes us to the important decision of mercantile credits and shell, which you can see is discussed at paragraph 5.55c of your casebook. And that comes under the heading of indefeasibility of the terms of a registered instrument. So what about if there are terms within this instrument which you can't see by examining the certificate of title? I know we've just earlier mentioned that we don't issue certificates anymore, but you know, when we did review the certificate of title, or today when we're reviewing the electronic details, electronically stored details, what does it extend to include? So in the mercantile credits and shell case, we had a scenario there that was involving both a lease and a mortgage in relation actually to a situation involving a garage, a service station, like a petrol service station. And the issue really revolved around this mortgage and also the terms of that mortgage and what did indefeasibility extend to include all of the terms within the mortgage. So the High Court in 1976 arrived at the following conclusions. Registration of an instrument does not necessarily give priority of the quality of indefeasibility to every right which the instrument creates. Only those covenants which are effectively part of the estate or interest in the land or are intimately connected with the estate attract the quality of indefeasibility. Now, this is really important because the indefeasibility is relevant with respect to the estate in land. We'll go back to our studies in foundations, where we looked at the doctrine of estates and the different types of estates that can be had in land. We're going to see going forward that this idea is also relevant in terms of the estate in land, in terms of the nature of the interest in the property, in terms of subsequent topics. So when we look at leases and when we look at easements and so on, we will see that as well in terms of the enforceability around the covenants, the terms that explain the substance of these rights and interests. Personal covenants, and this is very interesting, right? There's a differentiation here between a personal covenant on the one hand and a covenant which is part of the estate of the land on the other. Personal covenants which do not affect the estate or interest in the land are not indefeasible because simply they are contained within a registered document. So the court is distinguishing between personal covenants and covenants which are part of the estate of the land. An example of a personal covenant would be a guarantee, for instance. That is not a part of that which is part of the estate of the land from a property law perspective, and so it will not attract indefeasibility. Now, this is really interesting because these issues arise in the context of mortgages and very often, and the extent and how far they extend to include in terms of the provisions of the mortgage. And when we, as I say, the next slide talks about indefeasibility of what? And there's that whole article by Jeremy Stoljar, who was a barrister, looking at mortgages, indefeasibility and personal covenants. And then also the Van den Heuvel case. But within and this is discussed in the pages following in your casebook, in particular, from paragraph 5.557 and following. But I just want to point out to you that the Van den Heuvel case involved a situation of something which is referred to as an all monies mortgage, and that's discussed at page 5.59. And the all monies mortgage, which has become common practice, is that the mortgage does not relate to just a specified amount that's extended in a particular loan facility, because the mortgage is actually underpinned by a loan contract, separate loan contract. But the mortgagee, in the practice of mortgagees today, is actually to express them in more open terms as a all monies facility, so that it has greater flexibility. But you have to be on guard as lawyers as to whether or not standard documents include these provisions, or whether further special provisions and terms need to be incorporated within standard documents. And this is we're looking here at this area of mortgages from the perspective of indefeasibility and how far that extends. We're not looking at it at this point in terms of the law of mortgages, which we'll do in the last topic in the unit. So just be clear about that. But this discussion is quite important. It's dealing with the extent of coverage of indefeasibility, particularly in a mortgage type scenario, in terms of how far and what it actually covers. Right? And that's really the discussion in your casebook from page 445, really through to page 462. Now, just as I referred you there to the Van den Heuvel case, but just want to point out something in your casebook. So that it's important to realise that there have been some reforms to the legislation in terms of what mortgagees are required to do, and we'll have a look at those in subsequent lectures, in terms of what they need to do to fulfil their obligations as a mortgagee. And part of this relates to changes that have been made to the Land Title Act with regard to what's referred to as the verification of identity, or the VOI protocols, in relation to mortgagors. Because as we'll come to understand later in the last topic on the law of mortgages, a Torrens title mortgage, the land title owner is the mortgagor, and the bank, the financier, is the mortgagee. There's no transfer of title or anything of that nature where there is a mortgage created. The mortgage merely creates a security interest with respect to the land. Yes, the mortgagee has significant authority and powers and so on, which we'll learn more about later in the unit. But they don't become the owner of the land under a Torrens title mortgage. They have a security interest, and a significant one, no doubt. But that's what they have, and then we'll learn subsequently about what they can do in that regard. But just in terms of the Van Heuvel case, just be mindful of those legislative changes, particularly in Queensland, and how that impacts upon that. And then, as I mentioned to you before, just be conscious of the discussion with regard to volunteers, and that's referred to starting at paragraph 5.69 of the casebook, and that this is now dealt with in Queensland under the Land Title Act. And you can see on page 463, the Queensland statute expressly provides that a volunteer on registration obtains an indefeasible title under section 180. That is not the position in all jurisdictions. So again, if you're sitting outside Queensland, just be mindful of that. And this is one of the challenges in a unit of study like land law, which is governed by state-based legislation. You need to be conscious of the fact that the legislation does not have a mirror image in all the jurisdictions. Indeed, some matters are dealt with, for example, in Queensland, inside four corners of the Land Title Act, but in other jurisdictions are not, and are still subject to coverage by the general law or case law. So just need to be mindful of that. So that's the situation of how volunteers meaning those that take by way of voluntary transfer, where there's no consideration being offered, okay, how are they dealt with in terms of protections with regard to indefeasibility? Historically, where there wasn't this embedded within the Torrens Act, issues around whether a volunteer, that is someone who doesn't take bona fide a purchase for value, which was a historical position that was seen to be important. How does the Torrens system accommodate that? Well, in Queensland, through specific section 180, it gives them the same protection of indefeasibility as a purchase for value. Right, so in this first topic on the Torrens system, we've just touched upon the role, and just from more in historical terms, the Property Law Act with regard to the deeds registration system. Need to get our heads around the idea of indefeasibility and what an indefeasible title is. Need to reflect upon the developments with regard to the Torrens system, and in particular to focus on the Land Title Act and the Land Title Practice Manual in Queensland. Give some thought to the competition between these different theories of indefeasibility, and that the dominant theory today is immediate indefeasibility, and that means that you acquire title by registration upon registration. To understand the environment and the extent to which indefeasibility applies to individual terms in documents that are registered, and that differentiation between covenants within a document or an instrument that touch or affect the interest, the estate of the land, as opposed to personal covenants. And then lastly, just to be mindful of the position of volunteers and how that's dealt with in terms of Queensland. So, there we go, people. That's our first instalment on the system of Torrens title under the arrangements in Queensland, pursuant to the Land Title Act 1994. We will have two subsequent lectures and topics on this important and critical area. So, the journey into Torrens begins, and you need to see its contours. You need to understand its historical significance, but you need to also appreciate that how it works and functions today in a changing environment. And that changing environment is very much caught up with electronic conveyancing and the fact that documents and titles today are electronic in Queensland and in other jurisdictions. Certificates of title, and the Torrens register is computerised. Certificates of title or indefeasible titles don't issue as such. They're electronic documents that can be accessed and searched. The register is a public register, but we are in a in an environment of significant change, people. So as we will discover before we finish these lectures on the Torrens system, not only is this impact of electronic conveyancing needing to be appreciated, but other developments such as the commercialisation and privatisation of the Torrens system, the Torrens register, is also afoot. Not at the moment in Queensland, but 3 jurisdictions have decided to privatise the Torrens register. And that raises a whole number of issues which go to the question of assurance and state guarantee, which is one of the foundation ideas within the system. And we'll touch upon that more in the last class when we look at the idea of compensation. So for now, it's good night from me, and it's good night from him. Bye for now.